Students, today we can discuss one problem related to the voluntary non-fit injuria. That means here this concept voluntary non-fit injuria, we can see this concept in the general defenses available to the defendant. So here you have studied, that means which are the general defenses available to the defendant. That means there are nearly 13 the defenses are there. That is act of God, voluntary non-fit injuria, that is private defense, and inevitable accident, acts of necessity, mistake, statutory authority, judicial acts, quasi-judicial authority, executive authority, parental and quasi-parental authority, exercise of common rights, acts causing the slight harm. So these are all the general defenses available to the defendant. Likewise, it can be called as the justification of tort also. Here, it is very much what we call relevant with regard to the to refer the definition of the famous jurist Salmon. He has said that according to Salmon, no man can enforce a right which he has voluntarily waived off or abandoned. So here Salmon has given a beautiful definition with regard to the voluntary non-fit injuria. So here today we are going to discuss with regard to the problem on the voluntary non-fit injuria. This voluntary non-fit injuria will come under the general defenses or justification of tort, which will be available to the defendant. So here it is a very beautiful problem has been given in your previous question paper under the Karnataka State Law University examination. So before going to the problem, I thought of telling you with regard to which are all the steps you should have to follow with regard to solving any problems. So I used to tell in all the videos with regard to these problems, because majority of the students, they will not follow these steps. So what is the required thing from them required from them is not been complied of. So they could not able to score good marks. Easily you can score good marks by following these steps. Either you can follow FIRAC or IRAC, ILAC, or another method is there. Another method is there, that is PQRLM method. Here I don't want to go with regard to the other methods. Just I can concentrate only with regard to these simple aspects. That is, you have to highlight the facts. That means you have to simplify the facts which has been given in the problem, and you have to frame the issues. Here you can frame one issue or the more than one issue. That means depending upon the what has been given in the problem, you have to frame the issue. That is, in all my videos I used to tell you what is the importance of this issue. If you go to the final year, at that time you have been asked to do the practicals. So under moot court or mock court, at that time you should know this value of this issue. That means what is the difference between the plaintiff and defendant. So what is the issue, you will come to know. Not only here, if you happen to practice in the court of law, there also the importance of the issue is very much it is greater. So after framing the issues, the next aspect we have to see is that is a rule. So under rule we have to see the provision of law or the rule of law, or here we have to write the decided cases and we have to write the sections. So in law torts we don't have the sections. So here we have to write the provision of law, and next aspect is analysis. So in analysis we have to discuss all these facts, issue, rule, and we have to analyze these things in a very justified way, legally justified way. Then we can go for the conclusion. But normally the students, they jump into conclusion. So if they jump into conclusion, then there are less chances of getting the total marks or full marks. So in 80-20 scheme, you are having the nearly 30 marks is meant for these problematic questions. That's why students, please understand this the importance of this problem solving. Here it's not like the theory way of answering the questions. So the students, they tend to write the answers like theory answers for this essay for this problematic type of questions. Today, let us see the problem on voluntary non-fit injuria, the aspect. Here, what is the thing? What is what we can see here? We can see the problem. This has been taken from the Karnataka State Law University, the question paper. Here, there is this is problem with regard to the voluntary non-fit injury aspect. So, which comes under the general defenses or justification of tort. Here we can let us go to the problem. Here Raju was an employee in a stone quarry. He was testing some explosives in the site without wearing precautionary coverings, which were provided by the employer. Explosion took place and Raju gets seriously injured. Here Raju brings an action against employer to recover damages. Decide. So this is the beautiful problem has been given to you. You have to decide whether the employer will be held liable for the explosion which has been taken place at the quarry site, that is stone quarry site. Here employer has provided all the safeguards to the employee Raju, but he has not wore the safety kits. So whether employer could be held liable. So this is the thing we have to see from this problem. So what is the next step of our the steps of problem solving? We have to simplify the facts. So here Raju was an employee in a stone quarry and his job includes explosive testings used at site or place of work, and employer provided all equipments of precaution to be taken. Raju has not wore precaution equipments. There was a blast. Raju suffered an injury due to blast. So in this way we have to simplify the facts. Then we have to frame the issue whether employer could be held liable for the damages. So on the basis of these facts, whether employer could be held liable for damages. The simple way of framing the question, framing the issue. So this is the thing we have to discuss under this problem. So what is the provision of law is applicable here? Applicable provision of law is general defenses available under the tort. Just I have told you here voluntary non-fit injury. So at the same time the exceptions will also be applicable here. That is science, non-stay, violence and decided case law is Smith versus Baker. So these things we can see with regard to the provision of law. That means here applicable the provision of law is that that is voluntary non-fit injury, and we know the meaning of now voluntary non-fit injury. So here we have to discuss the exceptions with regard to the voluntary non-fit injury. So here the exceptions are that science, non-est, violence. So here what it says here, mere knowledge of risk is not enough. Mere knowledge of risk is not enough. Here knowing is not always voluntary. That is these things we should know. That means there are certain exceptions are there with regard to the voluntary non-fit injury. That is the exceptions are that is rescue cases under the Unfair Contract Terms Act of 1977, and certain aspects are there. Here we can include this. This will come under the some exceptional circumstances. Here what happens? Here the decided case law is Smith versus Baker. So here what are all the facts under Smith versus Baker is similar to this the facts of what has been given in this problem. Here in Smith versus Baker also the plaintiff was employed for cutting a rock, and here while he was working, a crane stone was taken from one side to another, and he knows that there will be danger. So at that time what happened? Due to the negligence of the other employee, the stone has fallen on the employee, one of the employee. It has caused damage. Here the court has decided that even though the person has consented to risk, he knows that there is going to be some risk. So the knowing is not always voluntary. That he is going to get suffered by the some damage. That means while at the working place the accident is inevitable. So the persons will go to work and they will suffer the damages. So mining and other some other aspects, the damages might it will be caused. So here we have to discuss the liability of the employer. Here we have to discuss the liability of the employer. Here the employer has provided all the equipments to the Raju. So here whether the employer could be held liable. Here we have to analyze the decision which has been given under the Smith versus Baker. Even though the employee has not taken so much of care. So it is the duty of the employer to see that his employee should be protected at any cost. He should not be, even though he has provided the equipments, he should see that the equipment should be worn by the employees and he should work. So then only there is some amount of defense the employer can take. Otherwise, even though he has merely instructed and he has provided the what you call equipments, then the liability of the employer, that is defendant, will not be. He cannot the liability will not be what you call exempted. So here the defendant will be held liable. So why this sort of the ratio aspect? Why this sort of the thing has been taken in this Smith versus Baker? Suppose such things has been this voluntary non-fit injury principles has been adopted with regard to the employer and employee relationship. Here majority of the employees, they don't get the compensation, they don't get the damages. Here equity principles has to be followed. So in the light of those things, so it is very much just and appropriate to award the damages suffered by the Raju. Here the defendant, that is the employer, would be held liable for the injuries caused to the Raju. So this is the good case law with regard to the voluntary non-fit injury. And you have to simplify the facts. You have to write the issue. You have to discuss with regard to provision of law. You have to do the analysis. Then you have to write the conclusion. As far as possible, I have limited all these things. And if you want, you can write some more aspects with regard to these things. But here, I think it is more than enough with regard to the 6 marks question. So in this way, you have to follow the steps with regard to the writing the answer.